Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, for a channel called Washington Gun Law, we spend a lot of time talking about a lot of other states: New York, New Jersey, Massachusetts, Illinois, Oregon. But the one state outside of the state of Washington that we spend a considerable amount of time talking about is, of course, California. And we talk about them for one of two reasons. Either A, some legislator down there has come up with an absolute insane idea of a law, and we'll talk about that. Or what's been happening lately and why we've been talking about California a lot is, well, candidly, they've been getting their ass handed to them in court. They're having a year about as good as Bud Light right now. Don't believe me? Well, let's just remember that the Ninth Circuit, just about a month ago, chucked out California's open carry ban in the case of Baird v. Bonta. Now, that's the Ninth Circuit, not the most Second Amendment-friendly court in America. Well, guess what? They've done it again, this time about a law that restricted certain types of advertisement as it relates to the firearm industry. So today, let's get you all up to speed and let's talk about another California gun law gets crushed by the court. Okay, so we're talking about California. Everyone knows that every time I talk about California, I'm going to give a shout out to our first ever California subscriber. That is Philip P. Philip P. has been spreading the gospel of Washington gun law down in the great state of California. So, Philip, this video is for you. The case we're talking about today is Junior Sports Magazine versus Bonta. Haven't heard of it, didn't get a lot of publicity. It's because the governor in New Mexico was grabbing all the headlines recently. But what this is an appeal of what started as Assembly Bill 2571, was then codified into California Business Code 22949.80. What that law did, it was going to save lives, and it was going to save lives by restricting how companies would be able to market their products inside the state of California. The law that's being challenged here specifically read, a firearm industry member shall not advertise, market, or arrange for placement of an advertising or marketing communication offering or promoting any firearm-related product in a manner that is designed, intended, or reasonably appears to be attractive to minors. And what that means is really anybody's guess. Now, the good news is that when this law was first challenged by Junior Sports Magazine, they asked for an immediate injunction in the district court. The district court denied that. It was then appealed to a 3-judge panel in the Ninth Circuit who has reversed that decision, okay? And let's remember what the good news is when a court says no, an injunction is proper, because when a court says that injunctive relief is proper, not only does it mean that the plaintiff in that case is suffering irreparable harm, but also that they are likely to prevail on the merits of the argument itself. And so this is a very, very positive sign that California Business Code 22949-80 is actually at some point going to be found unconstitutional. Let's get you through some parts of the opinion so you can understand where the court is coming from. Now, this is not a Second Amendment challenge to this law. Rather, this is a First and 14th Amendment challenge. So really, you can think about this. This is a First Amendment challenge. This is a challenge on restricting otherwise free commercial speech. The court summarized this issue as follows. This case is not about whether children can buy firearms. They cannot under California law. Nor is this case about whether minors can legally use firearms. California law allows minors under adult supervision to possess and use firearms for hunting, target practice, and other activities. And this case is not about whether California has the tools to combat the scourge of youth gun violence. It does. Rather, this case is about whether California can ban a truthful ad about firearms used legally by adults and minors just because the ad, quote, reasonably appears to be attractive to minors, end quote. So, for example, an ad showcasing a safer hunting rifle with less recoil for minors would likely be unlawful in California. Under our First Amendment jurisprudence, states can ban truthful and lawful advertising only if it materially and directly advances a substantial government interest and is no more extensive than what is necessary. California likely cannot meet this high bar. So, according to the court's analysis here, prohibitions such as this are permissible so long as it actually advances a true public interest and it is narrowly tailored to advance only that interest. And even with that narrow little road that California had to carve here, they were unable to do so. Now, of course, one of the arguments that California and all of these other states use is, but we need this to save lives. If you stop this law from being in effect, people are going to start dying. The court very wisely pointed out, while California has a substantial interest in reducing gun violence and unlawful use of firearms by minors, its law does not directly and materially further either goal. California cannot straitjacket the First Amendment by, on the one hand, allowing minors to possess and use firearms, and then on the other hand, banning truthful advertisements about the lawful use of firearms. And this is an argument that we see replete throughout all arguments advancing the cause of civilian disarmament, which is we need this to save lives. Now, there is no saving life exception to your otherwise inalienable rights. Or as the court put it, there is no evidence in the record that a minor in California has ever unlawfully bought a gun, let alone because of an ad. Nor has the state produced any evidence that truthful ads about lawful uses of guns, like an ad about hunting rifles in Junior Sports Magazine Junior Shooters, encourage illegal or violent gun use among minors. Simply put, California cannot lean on gossamers of speculation to weave an evidence-free narrative that its law curbing the First Amendment significantly decreases unlawful gun use amongst minors. And as the court really just summed it up, the First Amendment demands more than good intentions and wishful thinking to warrant the government's muzzling of speech. The court was also concerned that, hey, listen, you basically just wrote a completely overbroad law to strike down the ability of the gun industry to market in your state whatsoever. As the court found, California's law is also more extensive than necessary as it sweeps in truthful ads about lawful use of firearms for adults and minors alike. For instance, an advertisement directed at adults featuring a camouflage skin on a firearm might be illegal because minors may be attracted to it. And then most importantly, and this is why we want to carefully look, when we're seeing injunctions granted, this is a real positive sign. Because the court's ultimate ruling in this case is as follows. Because Junior Sports Magazines has shown a likelihood of success on the merits and the remaining winter factors favor it, we reverse the district court's denial of a preliminary injunction and remand. So this case is going to be remanded down to the district court with instructions to apply the law correctly. Presumably the district court would apply the law correctly, and there will be an injunction which will stop the state of California from enforcing their business code 22949-80. This is, yet again, a massive thumping that Gavin Newsom and Rob Bonta have taken, and this one, yet again, comes from the Ninth Circuit, and it has been the Ninth Circuit this year, which has been absolutely laying waste to many of California's civilian disarmament pieces of legislation. The case, once again, is Junior Sports Magazine v. Bonta. We'll link it all up down below so you can geek out on it yourself. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information's right down there in the description box. In the meantime, let's all remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.